thank you all for joining us today. My name is Ian Scott, and I am the founder of Scott Legal, and I'm joined today by Dustin Salvariaga, a fellow Harvard Law School graduate, and we are going to spend around an hour talking about E-2 visa options, and in particular, E-2 visa options when the investment amount is low or the case is a risky case. So before we dive into the particulars, just a few housekeeping items. So first, if you do have questions throughout the webinar, you can either use the chat box and add the questions there, or the question and answer box. We will get to all questions. We may not answer them right when you add them to either of those two boxes, but we do have time saved at the end, so we will answer all questions. Second, this webinar is being recorded, so it will be distributed after the webinar along with a number of other things. So we will send you a copy of the recording. We will send you an E-2 visa guide. It's a comprehensive guide that goes through a lot of the requirements that we're going to talk about today. We also will send you a link where you can set up set up in a consultation if you like. And we also will send you information on the upcoming webinars. We have webinars planned out through the end of July. And we will also be posting, I think either in the next couple of days, we'll be posting webinars right through to the end of August. So webinars on a number of different topics, including E-2, but also TN visa and other investor visas. The final thing to mention is that the firm was actually founded on an E-2 visa. So, you know, 10 years ago, 10 years ago, I was looking for investor visa options and came across the E-2 visa. And my first E-2 visa application that was filed was for my own company. And the company fit into what we're going to talk about today, what would be considered a low investment amount or risky case. So certainly in the questions, if you do have specific questions about my own experience, happy to do that. We were going through our second renewal now, and that should be done sometime in July. So finally, we do have a YouTube channel, and the YouTube channel has a number of different immigration videos. And also when we record the webinars, we turn them into a YouTube video and we post them to that channel. So we do encourage you to subscribe to our YouTube channel, and there is a notification button that will, if you click on that, then you will be notified when we do post new videos, and we do post 2 or 3 new videos every week. So without further ado, I will turn it over to Dustin to start the presentation.
Thank you very much, Ian. And again, congratulations on the 10-year anniversary. It's quite an accomplishment. Thank you all for being with us today to talk through the E-2 visa requirements and how they apply when we're talking about what we would call risky or low investment cases. We'll start by running through the basic E-2 visa requirements, which you see on your screen here. In the presentation, we'll go deeper into a number of these requirements. So for now, we'll just cover them from a very high level. In order to qualify for an E-2 visa, the first requirement is that the applicant must be a national of a treaty country. The E-2 visa is only available to individuals who are citizens and carry a passport from a list of about 80 countries that are called E-2 countries that have specific treaties with the United States. The applicant must own at least 50% of the E-2 company, so they can have a co-owner who owns the other 50%. It doesn't matter who the other co-owner is. It could be a US citizen or a green card holder, for example. And I should say all of these requirements are for E-2 investor visas as opposed to E-2 employee visas, which we will not be covering in this presentation, but we do cover in separate videos on YouTube. The third requirement you see on your screen is that the applicant must make an investment into the E-2 business. The funds that are invested must be what we call at risk. And what that means is the funds actually have to have been spent on the E-2 business. They need to have gone to items that are necessary for the business, such as paying for rent for an office or paying for inventory or equipment that's necessary for the business. What the funds cannot be is, for example, sitting in a business bank account where the investor can simply transfer them out of the account. They actually do need to have been spent for them to count toward the E-2 visa investment requirement. The government will ensure and will want to see that the funds come from a legitimate and lawful source. That's why you see on your screen that the source of funds is an important requirement. And that will require that we in the applications include documentation that clearly shows where the funds came from. Now, the positive side of that is that funds can come from a range of sources. As long as it's legal, most sources are acceptable with the exception of revenue that's generated by the E2 business. But we will talk a little bit more about that later in the presentation. The investment must be substantial, and we'll get into more details on that on the next slide. And we'll also talk about typical E2 expenditures as well as what are considered weak expenditures, and that we would probably leave out of an application. The investment amount is also looked at a little bit differently, depending on whether the applicant is starting a startup or purchasing an existing business in the US or starting a franchise. And we will talk about each of those later in the presentation. The fourth requirement, and this is really a key requirement, is that the E2 business cannot be what the government calls marginal. Marginality just refers to the business's ability to employ US workers. So in other words, the E2 business must employ US workers. What we generally recommend is that the business within 5 years of operations needs to employ at least 3 to 4 full-time equivalent US workers. It is not necessary that the business employ US workers at the time of applying. It's fine to submit a business plan that projects sufficient revenue and income that will support the employment of 3 to 4 US full-time equivalent US workers in 5 years. And then once the application, the time for the renewal comes up, you'll want to, of course, show that you've accomplished that. The marginality requirement, one of the reasons that it's particularly important is that it is an area that if other aspects of the application are relatively weak, for example, if the investment amount is relatively low, you can to some degree compensate for that by showing that the business already does employ workers, or that there's sufficient interest in the business to show that it very likely will employ a relatively large number of workers, or will employ US workers. So if you can show that this is a business that will clearly employ workers, it's less important to the consulate that you've invested a large sum of money into the business, generally speaking. And again, given that this presentation is about risky and low investment E2 applications, we will talk about that quite a bit more in this presentation. The fifth requirement you see on your screen is that the business must be real and operating. What that means is that, in essence, the consulate will want to see that once the visa is issued, all that needs to happen is that the applicant come to the US and is ready to get the business operating. So all licenses have been lined up, office space has been lined up, everything, the business entity has been formed, everything has happened that needs to happen for the applicant to come to the US and really hit the ground running when they get here. You see on your screen a few examples here of what we would include in an application to show that the business is ready to be real and operating once the visa is issued. Or very soon thereafter. A signed commercial lease, evidence that the business has been established, that the company has a website, that there are contracts with customers, and that any licenses have been acquired. The sixth requirement is that the applicant must be coming to the US solely to develop and direct the E2 business. This means a few things, one of which is that an E2 visa holder is supposed to devote their time and attention to growing the E2 business. They cannot come to the US to work for other businesses. They really are supposed to be here to grow their own business. They also need to be qualified to do that, whether that's through educational background or through professional experience, which we would also show in the application. And finally, the applicant must have the intent to return to their home country upon expiration of the E2 visa. The E2 visa is a non-immigrant visa. It's not a green card, and it does not directly lead to a green card. So the purpose of the visa is to allow someone to come into the US for a temporary period of time to develop and direct the E-2 business. Now, that being said, and Ian alluded to this in his introduction, the E-2 visa can be renewed indefinitely as long as the business and the investor remain eligible. So Ian started his firm 10 years ago, and as far as I know, he still has an E-2 visa, and he mentioned he's going to be renewing it. So you can continue doing that. He can continue doing that as long as he remains eligible, even though, again, an E-2 visa is not a green card and does not lead to a green card. So let's go a little bit deeper into a few of these requirements. Let's talk about the fact that the E-2 visa is a non-immigrant visa that allows nationals of certain countries to come to the US to develop and direct the operations of an enterprise in which they have invested. There's a lot packaged into that statement. You can tell it covers a number of the requirements we talked about. The one thing I will touch on, and that I think is sometimes not, people are not aware of it, is that going to this idea that nationals of certain countries, I mentioned before that there are about 80 E-2 treaty countries. Some of the countries that are not E-2 treaty countries are China, India, Brazil, countries that have a substantial population. It is possible for those individuals, if they have dual citizenship, or if they're able to acquire dual citizenship, for example, in a country such as Grenada, that offers citizenship through investment, then once they receive that passport from Grenada or another country that for which they are qualified to apply for citizenship, they would become eligible for an E-2 visa. So it is not uncommon for individuals from China, for example, from India, from Brazil, to apply for citizenship in a country that offers, for example, citizenship through investment. And once they receive their passport from that country, to apply for an E-2 visa. As I mentioned before, there are a number of options for obtaining an E-2 visa. The three most common, and really I think the universe of options really does fit into these three, is to do a startup, to start a business from scratch, to purchase an existing business, or to start a franchise. And we'll get into each of those a little more in this presentation. The way the application is structured does differ a little bit depending on those, but all three are viable options. In fact, consulates tend to have, what we've noticed is they tend to have a fairly easy time understanding the concept of a franchise, and they tend to, if there is an established franchise behind the business that you're starting, it does tend to carry weight with the consulate, where it's less of a question for them whether this is going to actually be a successful enterprise that employs US workers. If you're starting a startup, there's more uncertainty there because it is something being created from nothing, from just your experience oftentimes. But with a franchise, there's a track record there. Similarly with an existing business, if there is a business that exists in the US that already employs 3 to 5 US workers at least, that could be a very viable option for an E-2 business, because you're already able to show that this is a business that does generate sufficient revenue to employ US workers, and you'll be continuing that trajectory. I already touched about this next bullet. It must be a treaty between the US and the foreign countries. The 80 countries on the list are located in Europe, Africa, Asia, Latin America, and the Middle East. You can find the list by searching US Department of State E-2 treaty countries, or E-2 countries, and you'll see the full list there. The Department of State keeps an updated list. And finally, for how long is my E-2 visa valid? So this depends on your country of nationality. There is a concept in immigration law called reciprocity. If you've ever visited the US, you've probably run into the concept. The amount of time that the US gives a national of a specific country oftentimes is related to how long that country would give a US citizen to visit to visit the country. Similarly with the filing, the visa fees. Some countries have no reciprocity fee. Other countries, such as Australia, have a very high reciprocity fee, and that's oftentimes related to the way that that country treats US citizens and vice versa. The range of validity is, the maximum period of time is 5 years. The shortest period of time is 3 months. Excuse me. And what that really means is just the validity period for the visa. It's not the period of time that you can remain in the US after you enter. So to take an extreme example, if you are a national of a country that has a 3-month visa validity period, you would go to the consulate, you would get your visa, E-2 visa, it's issued for 3 months. Let's say that you enter the US on the last day of that 3-month period, the US would give you status for 2 years. So you would be able to stay in the US for 2 years upon each entry on your E-2 visa. Now, if you enter on the last day of your 3-month visa, you get 2 years of status, but you leave the next day, you don't have a visa to come into the US. You need to get a visa at the consulate in order to re-enter. But as long as you're able to stay in the US for that 2-year period, that's your period of status. I'll briefly note, and I think we do talk about this more later, and just so it's on everyone's radar, once you're in the US, there is the option, instead of applying for an E-2 visa at a consulate is the only place you can get a visa. You can't get a visa within the US. What you can get from within the US is status. So let's say that, going back to our example, you got a 3-month visa, you entered on the last day, you got 2 years of status. Let's say you're coming up on the end of that 2 years and you want to renew that 2-year period. You can do that from within the US. You would apply for an extension of status with US Citizenship and Immigration Services, or USCIS. If approved, you would get 2 years of additional status and E-2 status. Now, the downside of that is, again, once you leave the US, you need a visa to re-enter. So you would have to apply to a consulate. But if you don't need to leave, applying through USCIS could be a good option, and became a much more common option during COVID because of travel restrictions. How much investment is enough? This is one of the most common questions we get, and both fortunately and unfortunately, the government does not give a concrete answer. I say it's unfortunate because it does leave some ambiguity. I say it's fortunate because what it means is that if you can craft a good argument, it's oftentimes possible to be approved for an E-2 visa with a relatively low investment amount. And we'll spend some time talking about how to really craft that argument, specifically in the next slide, which Ian will cover, when you have a low investment amount. In general, what the government has said, though, again, they haven't defined a concrete dollar amount and said, okay, if you invest this much money, you satisfy this requirement. What they have said is that a few things. First of all, there's a proportionality test. And what that means is basically, the more the business costs to get started, the lower the percentage of money actually needs to be invested in the business at the time of the application. So to take an example, if you're starting a consulting firms, or even a law firm, have very low overhead. It's usually fairly inexpensive to get them started. Let's say that to start a law firm, it costs $100,000 to get it started. The government would want to see that close to, if not all of that money has been invested. They will want to see that the full $100,000 has been invested into the business, because again, that is a relatively low total investment amount needed to get the business started. In contrast, if you are starting a manufacturing plant, let's say you're starting a plant to manufacture batteries for electric vehicles, that could require startup funding of, say, $50 million. The government is more relaxed about wanting to see the full $50 million invested. They might say that is a large amount of money. So if it's $50 million, we might accept only 20% of that investment. We would want to see 10 million invested. That's the proportionality test. For the vast majority of the cases that we handle, our firm does specialize. We handle all visa types, but we've developed something of a specialty helping people who have low investment amounts. And in those cases, we almost always will recommend that the investor get to 100% of their investment amount. And there are really two reasons, two things the government's looking for in that investment amount. The first is the government uses the investment amount as a test to see whether the applicant is committed to the business. And the consular officer, it's keep in mind, this is a government employee. This is not typically an entrepreneur, not typically, an accountant. They are not looking at these applications from the perspective of a wise business decision. So when they look at an application, they want to see that this individual, this applicant in front of me, has put enough money on the line to make me believe they're committed to actually getting this business started and making it a success and employing US workers. The second thing that they're looking for in the investment amount is wanting to see that all of the things, all of the variety of items have been bought that are needed to get the business real and operating or ready to be operational once the visa's approved at the consulate. So what we include in our applications is a detailed investment schedule that lists line by line every single purchase related to the E-2 business, to really show that everything needed to start the business has been purchased, from office space to any employee payments, if that's needed, marketing, legal fees, professional fees to get the business started, things along those lines. I'll now pass it off to Ian to talk a bit more about strategies to deal with the low dollar amount.
Great, excellent. Thank you very much. Thank you very much, Dustin. So I think that, just because the topic of investment amount has, Dustin has just gone over that, and there are a few questions on investment amount that I think that we will deal with now, just before I jump into this. So the first question had to do with working capital and whether or not the working capital amount can be included in the investment amount. So there's an interesting history to this. So in the past, the regulation that governs E-2 visas that the consular officers used, in the past, there was a section in the regulations that said that a reasonable amount of working capital can be included in the investment amount. But a few years ago, the government, and they often update this particular regulation, a few years ago, they eliminated that sentence. And part of the reason is because there was a little bit of inconsistency in the regulation, because in one section it said that uncommitted capital doesn't count, and then in another section it said reasonable amount of working capital. So, but to answer your question is, we will still include it. So if there's a reasonable amount of working capital, we will include it. But it is not a viable strategy to invest $100,000 and put $100,000 into a business bank account and then go and apply for an E-2 visa. You will absolutely be denied 100%, no matter what the rest of the application looks like. It doesn't matter, that you'll be denied. And the reason is you haven't spent any money. They'll say that the $100,000 is sitting in a bank account and you could take it out if you want. So they'll say you don't have any funds at risk. If, for example, though, you had $100,000 and you spent $40,000 on an IT consulting business or some other type of consulting business, we would file the application. We would include in the application, as Dustin said, we would include an investment schedule, and then we would also include the working capital amount. But the question is, and this is a question that only a consular officer could know the answer to. The question is how much emphasis does an officer give to the working capital amount? And our thought is not very much, right? So on the one hand, the working capital amount has less to do with investment and more to do with the fact that, well, if there is more working capital, the company might be able to operate for longer without, even if they're not making revenue, they may be able to operate longer. So it's going to be viable. So it's almost, on the one hand, you might look at it more as something that relates to the marginality requirement than the investment requirement. But then on the other hand, you see that it was something that was included in investment a long time ago. And we figure that the worst that could happen is that, the worst that could happen is that the government just discounts the amount, right? So now that could be real bad, though, if if you've only spent $20,000 and they've discounted 80 of it, that's the 20,000 may not be sufficient. But so yeah, definitely an interesting question. Another question that came in is, how can an IT consulting contracting, is it eligible for E-2 visa? And really it's all service-oriented businesses are eligible for E-2 visas. And I think that the reason I'm talking about this one in the investment section is because maybe the reason the person is asking, because there's another question that the same person has asked, well, what can you spend money on? And I think that that's the big issue with service-oriented businesses, is that you are required to spend money, and probably, upwards in the 40,000 or so range, at least. But you have to find that, whether it's rent or hiring employees or marketing or computer equipment. So in a lot of instances, you end up spending money that you may not otherwise have spent. When I started my company and filed an E-2 visa, I had a lease, and the lease was the office space was $1,700 a month. And in all honesty, I didn't need a lease. I didn't need a rental space. I didn't have any clients. It was a complete waste of money, and I was locked into it for a year. So spent, over $20,000 for something that I really didn't need. However, I think it really helped me to get the visa. So, so it was, I guess, $20,000 well spent. So, okay. So yeah, so I think that we'll come back to the questions in a bit, and move on to the rest of the presentation. So I think that one of the key things that we kind of try and explain to people when they're, because one of the, as Dustin mentioned, one of the key questions that we get, or kind of the number one question we get during consultations for E-2 is, how much do I have to spend? And we always try and steer people away from that question, because two reasons really. One, because there is no specific answer, but two, because, it really is a question that the answer, it depends, is probably the best answer. Because I think that one of the things to keep in mind is, there are kind of three factors that we look at when we look at how much a person should spend. And one is the type of business, right? So if you're service-oriented business, it's going to be less. If it's some other type of, like if it's a restaurant, it's probably going to be more, et cetera. So one is the type of business. But the other is, how strong is your application, right? So when we say strong, like, what's your experience level? One of the things that the examiner liked about me is they liked my educational background, and they liked that I had a lot of business experience before. So they thought that I was going to be able to attract clients and develop a firm that would hire US workers. But it's even better than that when you apply, if you actually have employees already, because the investment amount is just a proxy to show that you are going to be able to ultimately hire US workers. So if you already have them, then that's, it doesn't mean you don't have to spend anything, but I think that what it does mean is that the government's going to think you have a much stronger application at the beginning, because you've already had employees. You don't have to now prove to them that the investment is going to be used to hire employees, because you're saying you've already hired employees. We had another client where she had invested a very low amount, probably $20,000, but we didn't ever think that her application was at risk, because she was a psychologist or psychologist or some form of a doctor. And she had a number of different insurance contracts that she was going to be assisting with treatment for a neurological disorder. And, that particular neurological disorder doesn't get cured. So it was going to be something that extended over a long period of time. And when an examiner sees, kind of doctor's office or variation on a doctor's office, they could easily picture employees working there, right? So her application, even though it was a very, very small investment amount, we looked at, what are the other areas of strength in the application. And, some of the other things that we sometimes get clients to do to bolster this is, if a client has letters of intent or contracts, or even going to their local chamber of commerce. And, this invariably clients say to us, oh, well, I spoke to the local chamber of commerce and they said they won't write me anything. We have a blog post that kind of says what the letter should say, et cetera. But with a little bit of tenacity and persistence, people invariably come back, and the chamber will write an excellent letter that basically says that we believe this business is going to benefit the local economy, because they'll look at your business plan, et cetera. And then the other thing, of course, is actually a business plan. And we do offer business plan drafting services, but the business plan is an important part of the application, if it's especially if it's a startup, because the government is using that to ascertain whether or not you are going to be able to achieve your goals of hiring U.S. workers. So we have a couple of examples here. Just to illustrate some basic points that we went over. You're opening your business, the investment amount is low, but you've already hired a couple of employees. The business is taking in revenue, so there's no viability issues, and you have a bunch of clients, right? So that's obviously a very good E2 case, even though the investment amount is low, right? Like even if the investment amount was a much lower amount, that would still be a good E2 case, as opposed to I don't remember this, but I imagine example 2 is a bad one. If you're applying for an E2 visa and the investment is low, but you don't want to invest anymore, you don't want to hire anybody until after the visa has been approved, and you want it to come to the US. And although it sounds like a silly example, like, oh well, that's just made up, but that happens all the time. Justin and I can tell you that many clients say, I don't want to spend money, I don't want to hire anybody, I don't want to get letters of intent, I don't want to do any of these. It's a service-oriented business. I don't want to spend, I shouldn't have to spend any money, but I want to apply for the visa anyway. But the fact is the law is the law, and it may not, the law sometimes doesn't make a lot of sense, but in order to get an E2 visa, these are the things that you have to do.
Perfect, thank you. So I know that there are a number of great questions rolling in. I think we'll touch on a few during the presentation, and then we have a question and answer period, as Ian mentioned, at the end, when we'll address all of them. So some common E2 visa expenditures, we've touched on this already. What defines a good E2 visa expenditure is really an expenditure that shows that all bases are covered in terms of everything's been purchased that needs to be purchased for the business to be operational. So if you are showing that you've bought something that the business clearly needs to operate, that is generally a good E2 expense. So on your screen, you see a number of these examples. They fall into several categories. You'll see one category is really marketing. So spending on marketing shows that you're putting an effort into generating interest in the business, which will lead to revenue and then employment. Also equipment that's needed for the business to run, any inventory. Not all businesses require inventory, but if inventory is necessary, that it's been purchased. Legal fees are generally a good expense to include. I would just say it would not be, you wouldn't want to rely on legal expenses, just because primarily just paying legal expenses doesn't make a viable business. It really, you should include them in general, but they should be secondary to things like equipment, like renting an office space, things like that. And I also wanted to specifically touch on the car truck example. So as you see on your screen, if the vehicle is exclusively used for the business, then it could be appropriate to include it. So as an example, we've had clients who, I'm thinking about one example in particular, who services pools, swimming pools. A vehicle, having a truck, was critical for that business. He had to carry his supplies. He had to carry an employee or two to each work site. So it was clear that having a truck made a difference to this business. I saw a question come in about buying a vehicle for an employee. Can we pay for a car purchase for the employee on an HR consultancy? I would be cautious about doing that. I'm not going to give a yes or no answer, because I think the answer really does depend on how well you can show that having a vehicle, your employee having a vehicle, is really critical to your business, and that the business really is not going to be able to function to the same level if you don't have a vehicle. Just be cautious that, because vehicles, especially if you're talking about a $100,000 overall investment amount, a vehicle could be 20% or more of that amount. And so what you don't want to happen is to show up for your visa interview and the officer to dig in a little bit about whether you actually need a car, to decide that you actually don't need a car, which causes a little bit of suspicion on their part that you may be padding your application and trying to hide something, and B, removes a significant part of your investment amount. So you do want to be confident that the things you're putting in your investment schedule are things that if you were asked about them in your interview, you feel very comfortable and confident explaining that they are necessary expenses. So on that note, switching to relatively bad or weak expenditures are really things that are not really necessary for the business. And we do see this sometimes. Clients will include in their list of expenditures money that they spent to fly to the US, to look at business opportunities, the expense of staying in a hotel while they were here, renting a car while they were here, maybe meeting with clients and entertaining clients. These are things that it's not necessarily clear that they're necessary for the business, and B, when it comes to entertaining clients, that can be something that directly leads to business, but it's not something that I think we would generally include. And part of that is really, again, getting yourself in this mindset. If you are in front of a consular officer and they see that you paid $300 for a business lunch or a business dinner, that's not really a conversation you want to be in defending why that meal was necessary. Rather, focus on the things that are clearly needed for the business and that you feel comfortable about, so that you're walking into the interview confident, the conversation is clear, and there really aren't opportunities for the consular officer to really ask, skeptical questions about any of these expenses. The other thing I'll note on this slide, which we do see often and is important, is when an expense is paid to a related party. So that could be a business associate, it could be a family member. We do see with some frequency individuals who are buying a business from a relative, for example, or they have a 50% owner in the business and they're buying something from that individual and counting it as an investment amount. You have to be very careful doing that. It's not impossible to do that. It's definitely possible to buy a business from a loved one and include that as an E-2 business. What you want to make sure to do is show that the transaction was really at an arm's length, meaning you didn't get any preferential treatment as or preferential pricing, that the pricing, the amount you paid really is the legitimate amount that anyone would have to pay. And also you want to show again that the funds are actually committed. If you're paying your business partner for a car, they own a car, you're paying for it, they're a US citizen, you're buying a car and counting it as your investment amount, is that money that you've actually committed, or is it money that's actually going to flow back to you? These are questions you want to avoid in a consular interview. So every step of the way, just make sure that these transactions are at an arm's length, are legitimate, and you should be fine.
Nelson, just to add a couple of just comments with respect to that, because I do find it interesting and almost sometimes funny in the sense that we get a laugh out of it. But one thing with respect to bad expenditures, right? They're not just what we think are bad expenditures. On some consular websites, they specifically list that they're irritated receiving invoices and receipts for these things like travel, meals, things like that. We'll get people including receipts for Chipotle, McDonald's, things like that. And they are like, they hurt your application. It's not even neutral. It's not like in the working capital where he said that's neutral. They hurt your application, and even consular websites say that. They say that these types of things hurt your application. So they're definitely not things. And the related party thing, it's it's one of those things where just a number of instances where I've been reviewing files, and as a reviewer, I'm reviewing it very critically, the way that I think an examiner would review it. And a number of instances where I've seen an expenditure that just didn't really make a lot of sense, whether it was, the way it was rounded, the amount that it was paid. And I've said to the lawyer, can you go back to the client and ask them if they're related in any way? I remember once I used the term, can you ask them if they're affiliated in any way? lawyer went back to the client came back and said, no, we're not affiliated anyway. But it was really bothering me. So then I sent the client an email saying, listen, this, I explained why. And then he goes, oh yeah, well, I own the company 100% that it was paid to, right? So, but my point is only that if I can see that, right, if these things bother me as I'm reviewing a file and I can see that there's something that is bothering me about this, right, then an examiner can see it. And if it gets to that stage, right, where you kind of don't really tell the lawyer it was a related party expense, because we have on our investment schedule, any related party expense investment, tell us about it. But, you don't really tell the lawyer about it. But if it comes up at a consulate, then, you not only will get the visa denied, but you could be hit with misrepresentation, right? Because that's really what it is, right? If you pay an amount to yourself and then count it on an investment schedule and say to the government that that you invested money, then an examiner will take that very, very poorly. So.
Absolutely. And Ian, I think this next slide, if you want to go ahead and go through that one.
Excellent. So, I think one of these things we talked about already, like, low investment amounts, consulting companies, many of the E-2 visas that we do are for service-oriented businesses with low investment amount. But really what you have to do is implement some of the procedures that we talked about earlier. I'm not going to go through them again, but contracts, hiring employees, et cetera. I think that in a lot of the cases when we have cases with low investment amount and we're doing the interview preparation with clients, what we're trying to do is get the client to think of themselves in the officer's shoes. Like, what would it take if you were the officer to convince this officer that you are going to be hiring U.S. workers ultimately? And again, it goes back to some of the things that we're talking about, whether it's your own experience, you may want to emphasize that, whether it's to strengthen an application, actually hiring an employee before. And people, I think you have to get out of the same mindset I was in when I was applying. Like, initially it was, well, I don't want to spend money on a lease I'm not going to need. Unfortunately, it's just for the purposes of getting an E-2, it's the cost of doing business. Like, you may have to hire someone sooner than you otherwise would have hired someone, or you may have to pay, money that you otherwise wouldn't have paid. Sometimes we have people prepay rent with either 6 or 12 months. Whatever you've prepaid, you can include in the rent amount. But sometimes they'll buy more equipment than they need, invest in marketing, hire employees. But really, when you go to the business, when you go to the interview, you want to be able to point to as many things as you can to really show that you're committed, right? Like, because even if you prepay rent for a year, because you're not even required to have a lease, but sometimes people will do month-to-month leases, in which that's fine too. It's better than nothing. But let's say that you have committed to a year for a lease, even if you've only paid 1 month up front, you can only include the 1 month in your investment amount. But the 1 year commitment goes to the second bullet point, where you're showing the government that you're committed to successfully operating a business, because you have a commitment in place that you are going to have to pay over time that you're not going to be able to get out of.
Sorry, Ian,
That's okay, no problem.
My power, here we go. Okay.
No problem. Perfect. Thanks. So the other kind of really fascinating area with higher risk cases are cases that relate to specific practice areas. So one is real estate investments, right? Now, the problem with real estate investments, so this can include home flipping, home renovation, property management company, starting a real estate brokerage firm. It can really include anything, but as long as it has the kind of name real estate in it, the reason these become sometimes problematic, and keep in mind, we do a lot of them, but they sometimes, or they're in the higher risk category, is because the government or the examiner may automatically have a bias and think that real estate is passive, right? So if we had one client who went to the US consulate in Frankfurt, he bought a home, the home had a mortgage, there were many issues with the case, the home had a mortgage, then he said he was going to do a home flipping business, went to the consulate and applied, and it denied. Right? He wasn't our client; he did it on his own or with a lawyer who didn't know what they're doing. So the case was denied. Well, because why was it denied? Because it wasn't a business, right? So it was. You don't need a visa to buy a home and flip it. Like you could do that. The government considers it a passive investment, almost like buying stock or whatever. So the idea with real estate investments is you have to show that it is a business that is going to ultimately hire U.S. workers. So you couldn't just have an LLC that owned a property. That wouldn't qualify because there are no workers associated with that. Even if you're renting it out, that's not a business. That's if you have, and contrast that to the property management companies that we've done where the company has 50 properties or so. So that does rise to the level of business because you're going to have to hire someone to collect the rents, hire someone to do maintenance, hire some, so the idea of hiring employees, that is going to be, required and ongoing. So that's it can't just be an idle speculative investment. So, and then we list a few like a lot of the times when people come to us and say, I want to do house flipping, what we try to encourage them to do instead is a kind of a renovation construction company. And one of the reasons, because the investment amount can be a lot lower, because if you're doing house flipping, then your investment is the houses. So you probably should have several houses before you, and they can't have mortgages on them because there's another rule that says that where you can't have the actual asset as the business asset as the security. So, but we do a lot of, renovation construction companies, really important that you have the license, but we do a lot of those. We've done some real estate brokerage firms, again, because we can show the government that we're going to be hiring US workers, real estate agents. And house flipping, as I said, it can work, but it just has to be on a grander scale. The other, and for the same reason, sometimes equity trading companies can be problematic. They just have to be positioned well. And again, because the government might see them and think that they're passive, initially look at them and think that they're passive in nature. So, the situations you have to really make sure that you don't, and we do, a lot of people come, they say, oh, well, I want to trade my own money and manage my own money, and can I get an E-2 with that? The answer is no. The only time this would work is if you were managing other people's money. So that means that there's a whole licensing aspect that's going to be required, because if you're managing your own money, you don't need a license. If you're managing other people's money, you do. And own money includes family money. So if you're managing just your family's money and your money, that's going to be problematic. You won't get an E-2 for it. But if you're opening up a trading company, like there are many large, the investment banks or hedge funds, et cetera, they're big companies that hire many workers. So, it's definitely eligible for E-2, but you just have to make sure that you get past the stage where the examiner might think that it's a passive investment. And as I mentioned before, it's highly regulated. So you just want to make sure that you, because there are very few industries where the consulate will ask for a license, but this is one of them. Same thing with real estate. If you're doing construction work, that's another area where we really encourage you to get a license, because if you don't, they might think that you're not able to operate. Perfect. Okay, so reasons for E-2 denials. I think this is a really important slide. If the company is a really large company, that's why we consider it not high risk. So, these reasons often come up in these riskier cases that we talked about. So, low investment amount, we talked about that. Most of the presentation has been, or a lot of the presentation has been about that. Nature of the business, we just talked about that, where the business is very passive. Or sometimes the nature of the business is something that an examiner just can't get their heads around, right? So easy businesses are businesses where the exam, like a restaurant, franchises make good E-2s. They're businesses where the examiner can get their head around easily that, this business is going to be able to hire US workers. But if you have to do like backflips to kind of understand what the business is and how it's going to work, and it's a business that you've never heard of and things like that, or, then that could be more problematic. It's going to require a lot more explanation, and it could result in denial. Filing location is a big one as well. Like, so if you're filing at consulates that do a lot of E-2 visas, like London, Toronto, then those are, consulates that are very predictable, and that's why we like filing at them. They understand the rules and they apply them, and so you're never surprised. But there are a lot of consulates around the world, in particular, the other group falls into two categories. One where they do know the rules, but they're just very, very difficult, in particular, no names. And then the other is a consulate that doesn't know the rules. So you might go, like, one consulate in mind we sent someone there that had a very, very strong application, and they were denied, and really for no other reason other than that particular consulate really likes, multinational companies coming there and things like that, and not the individual who's a service-oriented business, even though this particular person spent over $100,000, had employees in the US, and it was well positioned to create US jobs. So another big reason for denial, and this is a big reason and it's really hard to overcome, is, like, I'll give you a case where we had in London where the individual, and we warned them about this, and unfortunately, the warning came to fruition. They had a business in their home country for 15 years, an IT consulting business, and they had never hired employees. And in fact, the company didn't do that well. And we didn't stress it in the application, but the examiner went back, and I guess a lot of the information in the UK is public record. So they went back and they saw that this company hasn't done well over time. And they just didn't feel that the company was going to be able to hire US employees in the US, because the person was coming to the US to do IT consulting. So, and that's a very different one to overcome. If you have a low investment amount and you get denied, you can just spend more money and probably get approved. That's an easier one to overcome, as long as you have the money. The other question of concerns over whether the business will create US workers. So that's kind of a whole viability analysis. Sometimes when we review business plans, we're very skeptical of the business plans that talk about unrealistic revenues, because that will sometimes turn off an examiner, because the examiner might look at it and say that this isn't realistic, and as a result question the whole thing. Sometimes we have examples of, and this doesn't happen often because we do interview preparation, but unfortunately people are people and people have their own personalities. In the short time we're with them, we're certainly not going to be able to change their personalities, but they're confrontational, and we're confrontational with the examiners. And I recall one case where I was surprised that the person was denied. And then I had a conversation asking about the interaction with the examiner. And then it became clear to me, right, that the person that was in the interview, this gentleman, he was, I guess he thought that he had a right to a visa rather than it being a benefit or a discretionary privilege. And the examiner denied him. We actually ended up going to a different consulate altogether. But and his case was a strong one. He was actually someone who was approved at USCIS and then went to a consulate. His case was actually a strong one, but it was, confrontation he had with the examiner, where he could have easily not had that confrontation and probably been approved. And then the other is just that you don't meet the requirements. I'm shocked sometimes we get, pick up cases where so for example, the individual I mentioned to you where he applied, I don't know if he had a lawyer, I can't remember if he did or not, but he had one house, and forget the fact that the discretionary reason he was not approved because they didn't think it was a business, but he was actually ineligible from applying altogether because E-2 does not permit the asset to be the security, the business asset to be the security. So if there was a mortgage on the house, he was absolutely ineligible from applying. And that's it's not a gray area, right? That's the area they denied on, or the area I talked about before that they denied on, because they denied on both, is a discretionary gray area. You could argue that you could make the argument if someone buys a big house that there's going to be work for a lot of people. They may not buy it, but you could make the argument. Whereas the loan part, the mortgage piece, there's no argument that could be made. The person was never eligible. So I think that, the Biden administration, one of the good things with E-2s is not much has changed with respect to the adjudication of them. They've always been a visa that consulates have been trying to approve when the people are eligible. So that, there's no real change there. The only big issue is that consulates around the world are still very, very slow, right? That's universal. There are a few exceptions, but generally even the ones that are fast, they were always fast. So everyone's still trying to play catch up. Buy American, hire American. It's a policy that was, quite prevalent with the last administration, certainly not so much with this one. But we do tell people if they're investing that the investment should be, you know, at least some of it should be made in the US. And, you know, the consulates, it really is kind of, you need to, the only thing to take away from that bullet point is you have to, the timing is very consulate specific and timing specific. What is the timing right now will not be the timing in a month, et cetera. So, and then Dustin touched on the USCIS versus consulate, so we can move on from that. Okay, so let us go through these quickly. Okay, so some of these we answered during the presentation, so we'll go very quickly. So Dustin answered the question very clearly in the first few slides. Do I have to hire an employee before I apply for an E-2 visa? The answer to that is no. Complicated source of funds, Dustin also went through this. You know, especially if you're doing a USCIS filing, they take this very, very seriously. So you have to trace this down to an unbelievable amount of detail. Dustin also went over, you know, E-2 visa can be for 2 investors. So both investors can own 50-50, and that's not a problem at all. One thing that does come up, people who are in the US, let's say someone comes to the US and opens, you know, gets an E-2 for a restaurant, and then they decide that they don't want to do the restaurant business anymore and decide they want to do a consulting business. You can't just change, you know, it's entity specific, but you do have to go through a process to be able to be approved to be able to do that. And then Dustin already talked about the family business purchases, so we won't spend more time on that.
Great, thank you. And so we have a number of great questions that have come in. Ian, I'm happy just going down the list, or if,
yeah, perfect. Yeah,
you wanted to start with.
No, that sounds good. Yeah, we can do that.
Okay, so I think, you know, a number of these we did answer during the presentation. Does the money in the bank for working capital count as at risk? Ian answered that during the presentation, that it can be supplemental, but you should not rely on it alone. The validity period in the UK is 5 years. We have set up an HR consultancy firm. We'll have 1 US-based employee. We can pay for a lease for a year, a CPA. We can put cash in the bank. Does that count as can we pay for a car? I touched on that as well. Be careful with the car. Make sure it's specific to the business and necessary. Can an IT consulting contracting be eligible? Yes, it can be, absolutely. I think the thing that you should be careful of, I mean, IT consulting contracting, the issue is that it has very low overhead, right? Which is the focus of this presentation. So the answer is yes, but just make sure that you're satisfying that investment amount and that you can show that you'll employ 3 to 4 full-time equivalent US workers in 5 years. And obviously that you satisfy the other requirements, but there's nothing about IT consulting or contracting that should make it problematic innately for an E-2 visa. Can a TN visa holder switch to an E-2 as a consulting firm? You can. So basically a TN visa holder can file a change of status application with USCIS to change status to an E-2. All of the things that we talked about with USCIS would apply, including the requirement that you show where the money came from with documentation, and USCIS is going to hold you to a very high standard there. And so you really do have to do your own kind of financial audit and trace each dollar you've invested. But yes, you would file a form I-129 to change status. And obviously all the other requirements would apply. You have to employ workers within 5 years, etc. I established a cleaning service company 2 years ago. It's been working on low capacity to increase business, acquiring more contracts and more employees. Could I try an E-2 visa? You could. I think the big hurdle you'd have to overcome is the one that Ian talked about. When you have a business, whether it is a separate business in your home country, or if you have a business in the US that maybe you own, but you know, US workers are operating it, so you have not been the one operating it since you don't have a visa to do so. The issue is overcoming the negative track record. So you're going to have to include in your application some clear, believable, credible explanation about why the track record so far, whether that's been low revenue or low employment figures, why that's not going to continue when you submit your E-2 application, or it's not going to continue for your E-2 business. And that could be a number of things you could do. You could show, I mean, the most important thing to do, frankly, is to improve that problem, to address that problem before you apply. So if you have a business in the US, it's not employing workers, hire workers. When you submit the application, show, even though over the last 2 years we haven't employed anyone, in the last couple months we boosted hiring by 3 employees, by 2 employees. That makes a difference. It's not a guaranteed, silver bullet to address the problem, but that's probably the best thing you could do, as well as pointing to what you're doing to improve the business going forward. So whether increased investment, or you're trying some new marketing activities, you're pivoting, something should be in the application to justify that you'll employ US workers. Can a person on a TN apply for an E-2? The answer is yes. If denied the E-2, then will the TN be impacted? The answer is that it should not be. If you currently have TN status and you apply for E-2 and it's denied, it should not affect your underlying TN status. Ian, was there anything on that you wanted to?
No, that's fine. Yeah.
Okay, can US workers be freelance, or do they need to be on payroll? So that's a great question. Basically, the way you should think about this is there really is a spectrum. The consular officer ideally wants to see W-2 full-time US workers. And why is that? That shows that these are individuals who are probably receiving benefits from your company. Employment is probably stable. So you don't have workers coming in, leaving. It really is an employment opportunity, a stable employment opportunity for US workers, which is really what this is about. The whole E-2 visa, that's really what it's about. So weaker, as we move toward the weaker end of that spectrum, is part-time W-2 workers. That's still certainly a good thing. It's certainly fine to do. It's a little less persuasive than full-time. And also keep in mind, this is full-time equivalent. So if you have 2 part-time workers who add up to 1 full-time worker, that's generally fine. Farther down the spectrum is independent contractors, or as you're referring to, freelancers. These are really the weakest option. If you have a business that is dependent, some businesses, the business model is just dependent on independent contractors. That can certainly be approved, but what you'd want to do is you'd want to show that you're creating work opportunities for a relatively large number of independent contractors, A, and B, I would say, is show in the application, if you can, that these are contractors who stay with you a long time. These are people who really, you are creating a livelihood for people, even though they're not considered W-2 employees. So the answer is yes, but try to make, in your application, make it as persuasive as you possibly can. If the business is established in another market and expanding into the US, does that help the application? It can help the application if you can point to a track record abroad of strong revenue and employment figures. It can hurt the application if the business abroad has not been strong, has not employed workers, has not had strong revenues. Do I need to have a similar business in my country? The answer is no. You can start a business, fresh startup, just based on an idea in the US. You don't need the business to be operational in the US before you apply. It does not need to have generated a revenue, and it doesn't have to have generated a revenue abroad. If the business has not been operational in the US, you would want to rely on a business plan that really shows that over the next 5 years, you have reasonable financial assumptions backing up strong financial projections over 5 years. That will lead to the employment of at least 3 to 4 full-time equivalent US workers over a 5-year period. Are expenses being incurred by a UK business today eligible for the at-risk amount? I'm not sure what the question is asking. I think the answer is no. The expenses need to be spent on the US business, the E-2 business, showing your commitment to the E-2 entity, the US business. If you're starting a US location of an existing UK entity, which is fine to do, an E-2 visa can be used to open an office in the US, you would still want to show that you've invested money into that US office. So it's not enough to incur expenses in a foreign business and say that they're being spent on the US business. Now, If you buy things abroad, such as, let's say you're purchasing inventory from the UK, and that's going to be inventory shipped to the US, you can do that. As Ian said, you really should spend ideally most of your money in the US, but it is possible to count those expenses toward the US, toward the E2 business. Ricky from Germany. Hi, Ricky. In the case I buy a restaurant, I spend 70 to 80% of the capital, get licenses, recruit employees. Can I apply for the E2 visa now, or do I have to open and run the business before the E2? You do not have to open and run the business before you get the E2. If you're buying the assets of an existing business, the thing I would be mindful of is if the business already employs workers, I would encourage you to, if it's possible to keep those same employees, that makes for a strong application to show that you're going to continue employing workers. If you really are only buying the assets and you're going to start fresh, maybe you're completely changing the theme of the restaurant and you're going to hire all new workers, it's not necessary for the business to be operational. You would just want to include a solid business plan that explains what you're going to do with the new restaurant and how you're going to accomplish those financial projections and hiring projections. How about Airbnb managing multiple properties? I would point to what Ian talked about in the real estate slide. You really want to make sure that the business clearly is going to be real and operating. It's not going to be a passive investment where you've bought some properties and it's really just people staying in them. You really are going to need employees cleaning the spaces. You're going to need people, updating the properties, whatever it is. You want to be careful with really any real estate based E2 business, including property management, frankly. But property management is a real estate business that could work because you do generally need workers to do the work, and that's what the consulate is looking for.
We do, and we have at least one, but we may have two businesses that we've done E2s for that are exactly that business, that they provide services to. They don't own the Airbnb properties, but they provide all of the other services to the people who own the Airbnb properties in Hawaii. So, but that being said, you have to take into account all the other things that Dustin mentioned.
Perfect. And then I'm switching to the chat now. There are a couple duplicate questions. One great one from Andrew. How can we invest into the business when it is a new business and can be run from home? What do we need to spend money on? This is what Ian really talked about on the consulting slide. So you want to think creatively here. Are there ways to get even space at a WeWork, a dedicated desk at a WeWork? Is it possible to pay for space for 6 months to a year in advance? Is it possible to bolster your investment in marketing, for example? So, I don't think we would ever encourage a client to spend money simply for the sake of spending money if it doesn't in some way improve the business. What I just described are things like marketing where spending more money could result in increased revenue. Hopefully the space, there is a use for it as well. That it's not just throwing money away, it actually is an important part of the application. But you may need to think creatively, and that's something that we spend a lot of time on with our clients who are in that situation. Can I take funds from my friend as a gift who is a US citizen? The answer is yes. A gift is an acceptable source of funds. You would need to document both the transfer of those funds to you as well as where the person giving the gift got them. So for example, if this is a USCIS application, you would need to show clearly where that person giving you the money got the funds, whether it's selling an apartment, working for 3 years, whatever it is, you need to explain that with documentation. But a gift is generally acceptable. You'd also include a gift letter that explains that the person is agreeing to give you a gift. So Giuseppe, I have a restaurant set up to be open. Can I submit my application with USCIS or consulate now or wait until it starts generating income? You can do either. If it's viable, if you have people operating the business, you don't have to apply through USCIS. You can apply at a consulate. I mean, I don't know if you're asking about work authorization here. If you're in the US and you do not have work authorization, you cannot engage in activities that lead to income being generated for yourself or really for the business. You want to be very careful of that. But if you have employees who can run the business while you're here and you are not engaging in work, then you have the option to apply to consulate or through USCIS. May the investment amount come to the bank account in 2 or 3 different periods of time? The answer is yes, they can. What you want to be mindful of, though, is the sequence of events. So if you're saying to a consular officer, I've invested $100,000 into my business, and they say, well, where did you get the money? And you say, well, I sold my apartment. But your apartment was sold the week prior and you invested $100,000 over the last year. It doesn't make sense that you got money from the apartment that you sold last week and you spent the money a year prior. So just chronologically make sure that it makes sense when you explain it to someone, right? So you deposited $50,000 in September. So and you will deposit the remaining amount. So all of your business expenditures should presumably be after that first $50,000 hit the bank account. Otherwise, it just doesn't make sense logically. If a person wants to open a business and has no visa, can he be eligible for an E-2 to find an office and hire employees, or would there be another visa? That's a great question. The answer is no. So an E-2 visa is not to be used to either look for a business opportunity or really to set it up. When you're applying for an E-2 visa, once it's issued, you need to be ready to hit the ground running. That the business is set up, employees, you'll start hiring them. They don't need to be hired beforehand, but you'll start hiring them immediately. So how do you do that when you don't have an E-2? Oftentimes people will get a B1 visa if they need to physically come to the US, or use ESTA. Both of those allow authorized business activities, which is different from working. Authorized business activities are, for example, hiring workers, looking at office space, meeting with a business broker. Those are all things that are okay to do without work authorization if you're in the US on a B1 or ESTA, because you're not actually engaging in activities that are generating revenue. So B1 visa, ESTA, that's what you would be looking for to set up the E-2 visa. Do I have to show in my application that I have enough money left for the family's living expenses? It's a great question. The answer is, if you're applying at a consulate, probably not. At consulates, what we generally show is you spent $100,000 on the business. Here's where $100,000 came from. Here's how it flowed from the source to the E-2 business. If you're applying at USCIS, though, there's a very good chance they will want to see that you had enough to support yourself and your family. So you do have to show maintenance of a balance in that bank account and that it never dropped below what you're saying you put into the business. But if you are contemplating a USCIS application, that's something that an attorney really could help with. If there are any rules or laws for various companies on how much to invest, how many, I'm not sure what the question is asking. I'm not aware of any rules or laws that would define how many people or how much investment you need to make. And in terms of the federal government, it really is what we talked about. The consular officer will be looking at whether a substantial amount has been invested. That's specific to the type of business, and it really is at the discretion of the officer. And it's holistic as well, looking at are you already employing people with the amount you've invested, for example? Can we expedite our application? What's the cost? Very common question, unfortunately, because around the world, as Ian mentioned, consulates are extremely delayed. You can always ask a consulate to expedite your application once you've been given an interview date. So the way this works is you submit an application to a consulate, and typically they'll review the application and then tell you, okay, we've reviewed, now you can schedule your interview. And you'll see that the interview date is 8 months down the road. you would pick the available date, and at that point, once you have a date, you can request an expedite from the consulate. They do not have to grant it. They don't even have to consider your request, but you can always ask. USCIS, on the other hand, does offer a 15-day option. They charge $2,500 for it. If you submit your application to USCIS, they guarantee a decision in 15 days if you pay that premium processing fee. How much is legal fee? So we do have an engagement letter that details all of our fees. What I would recommend, anyone who's interested in discussing more, please do schedule a consultation. We credit your consultation fee to your visa legal fee if you decide to move forward with us, and we can get into the details of the cost. So Ian, I don't know if you had anything. I think we made it through all the questions.
Yeah, no, that's great. No, a lot of questions, a lot of great questions. That's excellent. And thank you all for joining us. As I said, we will send out a number of different things after this meeting, and also encourage you to, again, go to our Scott Legal YouTube channel and hit the notification button. And we look forward to seeing you all at the next webinar. And thank you very much, Dustin.
Thank you, Ian. Thank you all.
Bye.